everyone, and welcome to another episode of Workplace Matters with Broward County Bar Association. I'm Diana Castrillon, the co-host with
Henry Roman.
Nice to see you guys again, and we're very happy to have a distinguished guest with us here. This is part of a kind of a new platform design where we want to have folks here to talk to you so you can hear from perspectives other than just Henry and mine. So hopefully you enjoy that. And today we have the Honorable Thomas Hedler. Thank you for being here with us, Judge.
Thank you for having me.
So Henry, would you kind of get us started with this? Why don't you get us going?
All right. I've always wanted to ask this question. Do you buy your own robes, and does the state pay for the dry cleaning?
The state pays for the robe. The state will reimburse the dry cleaning, but I haven't submitted that in a while.
Okay, well, get those forms in quickly.
Yeah.
I thought it was going to be about the hair. Man, you missed an opportunity.
Well, I'm just jealous.
That was the one question. Now we do substantive, right?
We do.
We decided we were going to talk about something non-controversial, and we're going to talk about attorney's fees.
And before we even get to the topic, though, Judge.
I think they are non-controversial, so that's great.
Oh, well, that's already begun the controversy, hasn't it? But before we get there, so Judge, first of all, thanks for coming here. We know you're Palm Beach. You drove all the way down to be here. Tell us just briefly about you and how you got to the bench. You get a minute to give us your full story. Can you do it?
Your full CV in 60 seconds or less.
South Florida native. I've been in Palm Beach for 40 years. I did defense for a while, did claimants work for a while, and very, very last minute decided to apply. I was young. I was 41 years old at the time. And at that time, we were right around the stage of Miles and Castellanos, and I was doing claimants work. So I had a number of people telling me, that's really stupid, don't do this. But for me, I'd always wanted to serve as a judge. And I'd always just envisioned that, that's something down the road. I'll do that in my 50s and my 60s, whatever. And I just really felt comfortable with the notion of, if that's really what I want to do at some point, why not do it now? And if that's the career, if that's the fit, then go for it. And it's been an incredible blessing.
That's fantastic. Thank you. We appreciate it. That was, I think, exactly 60 seconds.
Yeah, we had time.
World record.
It's not my first time.
So now you can jump into the topic du jour.
Okay. Attorney's fees. So again, I don't find them, and I'm glad that you agree with me, incredibly controversial, as long as the documents support the fees. And can you just give us a little bit of a background on maybe why the executive branch of government has such an interest in attorney's fees payable by claimants or payable by claimants?
And I just want to say I find this highly controversial, but go ahead.
Wait, are you asking why does the JCC have to approve claimants' attorney's fees?
Right. Aside from the statute.
Why did the legislature put it in the statute?
Why protect the claimants from, I don't want to say they're lawyers, but why is that there from a policy perspective?
I could not tell you specifically the policy declaration. I will say that in Murray and in Castellanos, it did talk about, there is reference to the purpose of judicial approval of attorney's fees. And that is to make sure that, and the language is something akin to make sure that the claimant is getting their portion of the settlement. Why do I believe that it is important, or philosophically something that is a part of our workers' compensation practice? I think it's very analogous to FLSA. I don't know if you all have handled FLSA claims, but in FLSA claims, federal practice, it's similar in that you've got employees claiming that they were not paid appropriately, and sometimes they're shorted a little bit of money. And so they can't hire lawyers. You don't want that. The lawyers have to be able to represent them on a contingency basis. They get contingency paid fees from their clients if they prevail, and some would say or the lawyers can get paid by the employers. And so in FLSA, the federal judge has to approve the settlement. What they're approving is the breakdown, because they want to make sure that the employee, because there are differing ways for the lawyers to get paid, I think is where you start getting or inviting the judicial scrutiny. That's where you have to have the judge step in and say, wait a minute, let's just make sure, because it's not a straight up PI. And I know that's probably where the perspective on many on the claimant side, like, why don't we just get 33 and, a third or 40%? It's not that, because you can get paid your stat fee. You can get paid an employer carrier paid fee for securing benefits. You can get paid by an employer carrier paid fee for sitting through depositions without litigation. There are a number, you can get a claimant paid fee on the side. There are a number of different avenues for fees to flow. And when you have that arrangement, I think it is important then for judicial oversight of the fee to make sure that it all is legally correct and clear. Because when you have a situation where a client hires you and says, okay, I'll pay 25% or 30% or whatever your contract is, and then you litigate, and then you get to the point of mediation, and at mediation, you've got exposure for $20,000 in fees. You got exposure for a washout of $20,000. And then so the claimant is seeing, wait a minute, you're getting far more than 25 or 30%. You're getting a huge chunk, because they don't understand the arrangement and how you're getting paid in these different
isn't
scenarios.
That what the contract is for? I mean, if you have an explicit contract with a client, and look, we can get into battles as to why this is in the statute. At the end of the day, as a judge, I understand and respect that you're required to follow that statute. Whether you think this is the right thing to have in the statute or not, really probably is something that's somewhat irrelevant from the standpoint that once you're 100%. On the bench, right? But I disagree with the reasoning for this existing in our statute, because in other areas of law, there are also other ways by which the attorney can get paid, as in prevailing party fees. I mean, employer carrier paid fees are prevailing party fees in a personal injury or PIP claims, which I've done in the past for many years as well. In those cases, I can get paid from the defendant, okay, if I'm a prevailing party in securing some sort of benefit. Really, in PIP, it would be still benefit. In a third party case, there's a contract that explicitly says, okay, well, if I have to file suit and go to court, now your fee shifts to 40%. So in other words, these contracts very explicitly explain the sources from where I may receive payment if I'm a prevailing party from the defendant, the amounts that they're going to receive at different phases in the case, right? Pre-suit, post-suit, in-lit, pre-lit. So I think, I disagree, and I feel that it's unfortunate that as claimants, we're put to that level of scrutiny. But
okay, no, I'm surmising why I think the legislature put it there. Why do you think the legislature put it there?
I think it was an error. I think, like so many things that the legislature put in our statute, I think it had nothing to do with them really thinking it through. I think if we sit and look at our statute and the different iterations of our statute over the last, let's say, 25 years that I've been doing it, but certainly before that, the legislature has lots of things in our law that to me doesn't make any sense. I'm sure at the time that they were making the decision, there was somebody very smart who explained all kinds of things that seemed really smart to these folks, and that's why they included it. But honestly, as a claimant's attorney and in practice and in doing it for this long and having practice in other areas of law, I just don't understand it. I don't see where the oversight is appropriate. It does certainly make me feel as a claimant's attorney that I'm having to justify that I'm not, I almost feel like I'm guilty until proven innocent when I go to ask for an attorney's fee, and I'm only asking for sometimes 20%, most of the time 20%, whereas in my PI cases, I'm getting 30% without thinking anything of it. And my favorite is always when I hear, but you only represented the claimant for 3 months and now you want to get paid 20%. On PI cases, I've represented the claimant sometimes for a month and they tender. That's the contingency nature of the contract.
So let me push back a little bit then, because you're talking about a shift from 33 and a third to 40%. That's still just a shift in the percentages. That's not really a shift in how the fee is paid. You referenced PIP. And I'm ignorant on PIP, but I always thought of PIP as more of a prevailing party fee practice. It's not a
It's technically both.
Understood, but it's $10,000. I mean, I'm sure the vast majority of those cases are not getting paid by their client. It's a prevailing party provision for a reasonable fee or an hourly fee, and that's what they get.
In PIP,
and
yes.
so again, far more clean, right? But even if we circle back to PI, PI, I would surmise that it's accepted to do 33 and a 40% because there's a lot more margin for what you're dealing with in terms of you're not constrained to actual damages. You can open the door to intangibles. You can open the door to punitives. You can open the door to a lot more damages, whereas the injured worker is very, very limited. As you well know, they're limited on what they get while the case is open, and that limitation carries into the negotiations with your clients with respect to the exposures.
Yeah, but
they're not going to pay anything more than what they think they may have to pay, and even that's discounted. And that's only restricted to the medical and the indemnity. So
I disagree.
Hang on one second.
I'm still going to disagree vehemently.
But doesn't Murray and Castrillon speak to that?
Yes.
And speak to that from that perspective to say you have to have a system to make sure the injured worker is getting their benefits because they're so limited. There's so few. And so that's why...
I'm not letting you speak, Henry. I've waited.
No,
I've waited because our honorable judge here has asked me to, but you, I'm going to say, hold on.
Okay.
So, and then you'll get a minute.
It sounds a lot like yours.
You might be, but
you don't want to take that chance.
Here's the thing.
And again, just to be clear, I'm only reiterating what I read in Murray and Castellanos, and what I surmise is the driving factor. I represent injured workers. I've been called in for questions on fees.
And listen,
I have
recognize
personal feelings and thoughts on the matter that are separate. But if I'm trying to be objective, I'm trying to read the cases and trying to understand how the practice operates. That's the way I interpret that in terms of foundational philosophical. But go ahead, sorry.
No, Judge. And listen, obviously, look, this is a conversation. This is an informal conversation. It's meant to be somewhat tongue-in-cheek. It's meant to be some devil's advocate portions of it.
I got a lot of cheek.
Listen, I'm Cuban.
I've seen these prior episodes. They did not go like this.
This is, you're in the hot seat for a reason, Judge. No, but here's, I may leave it at this, but this is my response. The perspective that workers' comp is so limited and the benefits are limited, and in the world of PI, there's just it could be anything, right? Billions of dollars. Guess what, guys? There's policy limits. So you are limited in personal injury cases, in cases where the value of the case where you could significantly collect more under the same circumstance if there wasn't a limited policy. So in a case where there's only a $20,000 policy, why isn't there somebody looking at that and going, well, you shouldn't get 33 1/3 on that policy because there was only 20 grand, and look at this poor guy, nobody's looking at that. Whether it's right or wrong, I'm not saying whether that's right or wrong. The point is, nobody needs to oversee those people, but they need to oversee me as a claimant's attorney. That's where I have a problem with it. Again, it's in our statute, whether I have a problem with it or not. I have lots of problems with lots of things that I have to do every day, right? But that's not the point of the story. And I understand, Judge, that of course you're giving us a perspective. This is the devil's advocate. This is the reality. It's what's in our statute, and it's the law that you have to follow and that I have to follow, unfortunately, sometimes. And I get that. But I do think that there are definitely probably 30 sides to this story, much less one or two. But Henry, please feel free to interject now.
Okay. Going along the theme of this being non-controversial, and I'm glad Diana bought into that theme.
Me too.
You mentioned Murray, Castellanos, and there's another case out there, Miles, that has a different interpretation and certainly a different application day in and day out, at least in my practice as I see it. What I see, and there's a question here, I promise. What I see often is in cases where we resolve the case via settlement and there is the motion for approval of attorney's fees and child support allocation, claimant's counsel wants quote unquote a miles fee, and that's starting to vary now. I've seen it as low as 20. I'm seeing retainer agreements, tipping over on the 40% side.
That's
But
how contracts work, Henry.
but they
Just put
all-
that out there.
Is it? But I'm also seeing a straight stipulation for benefits and also attorney's fees there. Is that permissible?
Is it legally permissible?
Yes.
Would there be any law that says it's not?
But that's not a situation where instantly, not you, any judge other than you, sees that, I was going to say scheme, but I didn't mean that, sees that separation.
Is that a Freudian slip?
Yeah, it was intentional. So if anybody's paying attention, sees this arrangement and reflexively say, no, there's just no way I can improve that. Or is it a function of, as long as claimant's counsel can substantiate her work to justify the fee, is that permissible in the same, let's call it, space?
I can't speak to what other judges do other than stories of lore that I've heard. I have approved miles plus fees when the documentation supports it. I don't think they are illegal, impermissible. They invite greater scrutiny, but I think a very pragmatic reason for that is you're dealing now with two separate fees. Both of them, I'm presuming the side fee is a reasonable fee or a reasonable hourly fee. It's a Castrillon's fee. It's not a stat fee.
Right.
So both of them then require an affidavit from counsel in support of an excess fee. So that right there should tell you, oh, this is going to be looked at. You're seeking that which is more than what the statute provides. So there are affidavits for that, and those affidavits are going to be looked at. So when you have an affidavit in support of a miles fee, and then you also have to have a separate affidavit in support of the side fee, it would be a good idea for lawyers to make sure they are distinct. I can tell you it's not uncommon for them to be almost mirrored, and that doesn't really help because the affidavit is in support of the excess fee. So why is this miles fee reasonable? Factors. Why is this fee over here, side fee, reasonable? Factors. Should be different factors. But oftentimes what you get is I represented an injured worker for X amount of days. They owe me a fee. They're going to pay me $10,000. There's going to be 30 hours towards that, but I got 100 hours in it. So I got 70 left over. So that's what justifies this. So then you're forcing the judge to go strictly to a resulting hourly rate mechanism, which I'd like to think all of us can agree that's not appropriate. Right? I mean,
That's
the Florida
right.
bar does not want that one factor to be the driving factor.
Correct.
And I hear complaints from lawyers all the time, like, well, the judges just focus on the resulting hourly rate. Well, that's not good, but are you forcing the judge into that analysis by only relying on the resulting hourly rate in your affidavits?
So,
And
Judge,
just to remind the viewers, all for you, just to remind the viewers, when we talk about factors, we're talking about the Lee engineering factors, right? Or the
We're
factors
talking
that
about
are
the
set
Lee
forth
engineering factors that were codified in the Florida bar rules.
Right. Okay.
Correct.
which is more than just hours.
Correct.
There's
it is
all
certainly more
sorts
than
of things.
just hours. Yeah.
A lot more.
Right.
And yet, I know one of the things that you had sent over to me was we're going to talk about the evolution of attorney's fees. I would say the affidavits are where we're at in many respects on the evolution because the affidavit is really oftentimes the problem child with approval of these fees.
Yes, and I've heard many judges tell me over the years, at conferences and meetings and just informal discussions, saying we have no problem awarding an appropriate and reasonable fee under the statute. In fact, that's what our job is here to do, as long as you're providing us the information that we need to do that. So it definitely all, I mean, the affidavit and affidavits really, because when we're talking about these two different types of fees, it really all comes down to you as the claimant's attorney, when you're seeking payment of a fee, need to give the court the information that they need to be able to give you that fee. It does come down to the lee engineering factors, and it does come down to, you cannot have boilerplate language that is in every single affidavit and it reads the exact same way every time.
That's right.
So
And I see
it's
that
important.
way too often, and even
Way too often.
and even before I think this is supported by the case law. That the court still needs to find an exceptional circumstance or exceptional circumstances to deviate from the presumptive fee.
That's an
I
interesting
disagree
theory.
with that. I strongly disagree
I'm
with
going to
that.
send you some of my pleadings because
Please do.
I firmly believe that.
So I can set them
Well,
on
hang
fire.
on one second. Let me try to play moderator here. I think what you're referencing is fees that are in excess of the statutory guideline.
Right.
And I think your strong objection is, as it applies to miles, that the starting point shouldn't be the stat fee, or should it?
It's like
That's
you
a
read my
question.
mind. But yes.
You want the starting point to be the contract fee,
contract.
predicated upon the waiver, and that's a whole other discussion we could talk about. But that's where that conflict. But you're still pushing for. You think that applies across the board to
and
miles.
I think the exceptional circumstances are the lee engineering factors that have been codified. I think and this goes to your point, just throwing out, I spent 32 hours. Okay, but what did you do? What are your time entries? Was it a complex issue or not so complex issue? Could have been
Maybe
handled.
your client should pay you less if your motion wasn't as complex as the one before.
It's okay. I'll live with that. But the point is, I think that I agree. I don't think I agree. I agree with you. I think that affidavit is very, very important.
Well, before I get in trouble, because I can see where this is going, I just want to make sure we're clear on one thing. Miles fees, I think the affidavit is very important. Side stipulations, it's part of the puzzle.
Okay.
And that's where the stipulation language is important. The attorney fee data sheet is important. And then the affidavit is batting cleanup. If you don't lay out the bases for the fee in the stipulation in the attorney fee data sheet, then you got to let your affidavit do some heavy lifting. And this is going to get into that realm where, you get those scenarios where you say, I don't agree to the fee. I'll pay it, but I don't agree. Mm-hmm. And you get those squirrely stips. And then that's when the attorney fee data sheet's very important. And then that's where the affidavit comes in strong. Now, if you come in and say, oh, no, she's due the fee. She filed the petition. She got the benefit. She's due the fee. We stip to entitlement back then. We're agreeing to pay this amount. The attorney fee data sheet lays everything out. Well, then the affidavit is really just, I don't want to say formality, but at that point, the stipulation is very clean. It's a lot less scrutiny then where you're really pouring through the affidavit. But if in the other scenario, the affidavit's got to be very important. So it depends on what we're talking about, which I think is probably your point in terms of, we're talking about miles, we're talking about side fees.
Right.
The affidavits, either way, I think are very important. They're critical on miles. I am very interested. I'd love to hear you kind of expand upon your belief that judges should make specific findings. I'm putting words in your mouth. That the stat fee is manifestly unfair, and then they're approving the miles as opposed to just assessing the miles fee as it stands.
I have an opinion. No, I have.
Good job.
I have an opinion. I think the stat fee is the presumptive fee. And if you want a deviation...
Certainly what we learned in Rudolph.
Right. If that's true. If there's a deviation there, upward or downward, because I do believe that there's room for both, I think that it's incumbent upon whoever's prosecuting that fee or the claim for that fee or the amount of the fee to show the judge by way of affidavit or live testimony, however he or she chooses, number one, exceptional circumstances to warrant that deviation, and then well, what's the amount of the deviation, right? So the exceptional circumstance, I always looked at it as from, those are the Lee engineering factors. The complexity of the issue, right? We put neutral factor, positive factor, negative factor. So you start looking at those things, and then you say, okay, this is a different case than your just run-of-the-mill case. So this warrants an upward deviation. And now you're looking at the amount of that deviation. Does it comport with the rate in the locality, the number of hours, the billing entries? That's where I think, much like in an award of a disputed amount, I think that analysis is there for the judge to have. I could be wrong.
I mean, you are wrong. However, only and maybe somewhat more so within the context of a miles fee, because I think, one of the factors that's important for the court's consideration, as well as for anybody who's looking at it, is a contract and an individual's right to contract. And the factor that also has to be considered that maybe you didn't really talk about much is, if they contract and agree that they're going to pay their attorney this specific amount, and they do that knowingly, and and they're letting you know that because there's an affidavit where they're letting you know that, there's also a contract that they signed, and that's being provided, there needs to be weight given to that document. And in all the factors you mentioned that are in Lee engineering and are correct, that's not something that was discussed. And I think that that's very, very important, because it's something different. It's something that didn't exist when Lee engineering happened, when it was codified, but it is very much a factor in our lives and in our practices now.
I agree.
So I think if you look at that, then that makes your entire analysis have a humongous problem, because you're starting with a presumption that, in my opinion, is wrong. But that's a conversation for another day, because at the end of the day, we have the judge who came here to give his perspective to us, and which we very much appreciate. So any final words, Judge, to the members of the bar as to attorney's fees, or where we're going, or where we're at?
The judges would love to get cogent motions, affidavits, attorney fee data sheets, retainer agreements, waivers, everything that makes sense and is clear, and there's no question, and orders are entered same day. So to the extent that that can happen more, I think judges would welcome it. I don't think that's a controversial statement. I don't think there'd be a lot of judges that would disagree with me.
I agree, Judge, and I guess at the end of the day, what I'm hearing is we need to make sure that we're properly documenting. We need to make sure we're giving the court that information which they need, and we need to treat those documents with the care that they deserve, because they're going to be looked at by the eyes that will ultimately decide the result of it. And so, making sure they're not sloppy, making sure the information is cogent and everything follows, and giving the court what it needs to ultimately just rule. If we make it easy on the court, then the court is going to rule in our favor, presumably. So I thank you.
And quickly.
And that's my favorite actual part of it and component. And so again, Judge, we're going to thank you for your time.
Thank you, Judge.
And on behalf of the Broward County Bar, thank you for being here with us today. So that concludes another episode of Workplace Matters. Thank you guys for joining us. Add any questions you have for the judge. Let us know what topics you'd like to hear about next, and we hope to see you next time.
Thank you.